Everyone told me I couldn't fight him. I filed in court on a Thursday. He had to show up with a lawyer and answer questions under oath. Part 1. The yellow envelope. The envelope was the color of a parking ticket. I noticed it the second I unlocked my door, a thin rectangle of yellow against the brown carpet of the hallway, half tucked under the threshold like whoever slid it there had done it quickly, without wanting to be seen. It was a Tuesday in February, just past 7 in the evening, and I was still in my scrubs. I had been on my feet for 10 hours. I had cleaned 11 sets of teeth, counseled 4 patients on flossing habits they would absolutely not change, and driven 40 minutes home through Atlanta traffic with the radio off because sometimes silence is the only thing left that costs nothing. I stood in the doorway for a moment, looking at the envelope. Then I picked it up, went inside, set my bag on the kitchen counter, and opened it. Notice to vacate. 30 days. I read it once. Then I read it again. Then I sat down on my couch in my scrubs and read it a third time, slowly, the way you read something when you're hoping the words will rearrange themselves into something that makes more sense. They didn't. The notice was signed by my landlord, a 61-year-old man I had met exactly twice in the 3 years I had lived in this apartment. Once at move-in, when he handed me keys and barely made eye contact, and once in the parking lot about a year later when he was inspecting the building's exterior and nodded at me like I was a stranger, which I supposed to him I was. The stated reason for the eviction was printed in a single line near the bottom: lease violations. That was it. No specification. No list. Just lease violations, like that was a sentence and not an accusation. I want to tell you that I immediately knew what to do. I want to tell you that some confident, strategic part of me activated right then and laid out a plan. That's not what happened. What happened was that I sat on my couch for about 20 minutes feeling a specific kind of dread that I think anyone who has ever been financially precarious knows well, that cold, dropping sensation in your chest when you realize the floor beneath you might not be as solid as you thought. I made $52,000 a year. I had $2,200 in savings, $28,000 in student loan debt, and a 2016 Honda Civic that needed new tires I kept putting off. My rent was $1,340 a month. Actually $1,340, sometimes paid on the 28th of the prior month because I am anxious about money and paying early feels like a form of control, the way some people check whether the stove is off 4 times before bed. I had never missed a payment. I had never been late. Not once in 3 years. After 20 minutes, I did not call my mother. I did not call my best friend. I did not open Zillow or Apartments.com to start looking for somewhere new to go. I opened Google and I typed, "Tenant Rights Georgia Eviction." That search is the beginning of this story. Everything before it is just context. I did not sleep much that night. What I found in those first few hours was not legal expertise. I want to be clear about that. I was not equipped to read case law or parse statutory language with any real fluency. But I could read. And what I found when I started reading was something that surprised me. There were rules. Actual, specific, enforceable rules about how a landlord in the state of Georgia is allowed to evict a tenant. The eviction notice I was holding in my hand was not just a piece of paper my landlord had chosen to deliver. It was a legal document, and legal documents, I was learning, have requirements. By midnight I had learned that Georgia law requires eviction notices to specify the lease violations being claimed. Not gesture vaguely at them. Specify them. Lease violations with no further detail is, legally speaking, insufficient. By 1 in the morning I had found the Georgia Landlord-Tenant Act and started reading it the way I read patient charts. Carefully, making notes, flagging things I didn't understand to look up separately. By 2 in the morning I had 4 words written on the notepad I keep next to my couch for grocery lists and appointment reminders. I need a lawyer. I put the notepad on the coffee table, turned off the light, and lay in the dark thinking about what the next 30 days were supposed to look like according to the man who had slipped that envelope under my door and gone home. He thought this was over before it started. He had absolutely no idea. Part 2. The education. The next 2 weeks were unlike any 2 weeks of my adult life. I am not someone who reads legal documents for fun. I am someone who reads dental hygiene journals and occasionally a thriller novel on weekends. But I sat down with my lease, all 14 pages of it, which I had not read in full since the day I signed it 3 years ago, and I went through it with a yellow highlighter, the same color as the envelope, which I decided was fitting. I also read the Georgia Security Deposit Act, the Georgia Fair Housing Act, sections of the Federal Fair Housing Act. I printed things out. I made a folder. I built a timeline in a spreadsheet, because I work in a field where documentation is everything and I have been trained since dental school to record, date, and organize. Here is what I found. The mold. 14 months before I received that eviction notice, I had submitted a maintenance request through my landlord's official property management portal. the one he required all tenants to use, the one that automatically timestamps every submission, reporting mold on the bathroom ceiling. I had submitted a second request 7 months later when nothing had been done. Both requests were in the portal. Both were timestamped. Both had received the same response, a text message from a number I'd learned was his property manager's, saying it would be looked at. Nobody had ever come. I still had the mold. I still had the requests. And I had photographs, dated, geotagged photographs taken on the day of my first submission, because I am anxious and I photograph everything that worries me and have done so since smartphones made it easy. Georgia law requires landlords to maintain rental properties in a habitable condition. Mold that materially affects air quality is a habitability violation. My landlord had documented notice of a habitability violation for 14 months and had done nothing. I had 18 months of increasingly frequent sinus issues. I had 2 doctor's visits on record, appointments I'd made for what I thought was just bad seasonal allergies, noting environmental irritants as a likely contributing factor. That mold photo was about to become the most expensive picture I have ever taken in my life. The notice. I already knew the notice was defective, it hadn't specified the violations. But the more I read, the more I understood why this mattered. A legally sufficient eviction notice is a prerequisite for a valid eviction proceeding in Georgia. You can't build a case on a defective foundation. The notice my landlord had slipped under my door was not legally sufficient. He had skipped a step that the law considers mandatory. The retaliation. Georgia law prohibits retaliatory evictions. Specifically, landlords cannot evict tenants in response to tenants exercising their legal rights, including the right to request repairs. I had submitted my second mold request 7 months before I received the eviction notice. I had been a perfect tenant for 3 years by every measurable metric. And in the 8 months before the notice arrived, I had noticed something. 3 apartments in my building had been vacated, renovated, and relisted. I had found the listings on apartments.com while I was doing research, and I had screenshotted all of them. The relisted units were going for $1,750 a month. I was paying $1,340. I was, in the financial logic of a man who owned 6 buildings, $410 a month of lost potential revenue. The timing was not a coincidence. The economics told the story clearly. The security deposit. 3 years ago, I had paid $1,500 as a security deposit. Georgia law requires landlords to provide written notice of where the security deposit is being held within 30 days of receiving it. I went back through every email I had received from the landlord or his property management company since 2021. I searched every term I could think of. There was no such notice. Not once in 3 years. The Georgia Security Deposit Act specifies that failure to comply with this requirement entitles the tenant to statutory damages of 3 times the deposit amount. 3 times $1,500 is $4,500. That was the floor of one piece of my case, and it required nothing more from me than the absence of an email he had never sent. I brought all of this to an attorney on a Friday afternoon, 11 days after I found the yellow envelope on my floor. Her office was in Midtown, 3rd floor of a building that smelled like coffee and old carpet. She was 38, direct, with the kind of focused stillness that I associate with people who have heard a lot of stories and learned to listen for what matters. She read through my folder for 45 minutes while I sat across the desk from her and tried not to fidget. She asked me 4 questions. I answered all of them. She looked up. "He picked the wrong tenant to evict," she said. I exhaled for what felt like the first time in 11 days. She told me she worked on contingency for tenant cases like mine. I didn't fully understand what contingency meant until she explained it. She would take her fee as a percentage of whatever we won. I paid nothing up front. I would only owe her if we prevailed. The fear my best friend had planted, "You're going to spend more on legal fees than you'll ever win," dissolved in that moment, though I didn't know it yet, because I didn't yet understand what we were building. I left her office with a legal partner and a plan. He had slipped that envelope under my door thinking it was a form letter. He had handed me a reason to read my lease for the first time. He had no idea those were different things. Part 3. The Case. Update 1. Month 2. My attorney filed our response to the eviction in Fulton County Court the following Thursday. We challenged the notice as legally defective on its face, insufficient specification of violations. We raised 4 affirmative defenses: habitability violation, the mold, retaliatory eviction, the timing and the relisting pattern, security deposit non-compliance, the missing written notice, and breach of the implied warranty of habitability. Simultaneously, she filed a civil claim against the landlord for damages for mold exposure, statutory damages under the Security Deposit Act, emotional distress, wrongful eviction attempt, and attorney's fees. The landlord's attorney was aggressive. I had expected dismissal. I think some part of me had expected them to look at the filing and laugh, because I was a dental hygienist and not an attorney, and I had been conditioned by 31 years of life experience to believe that institutions were impervious to individual challenge. Instead, they filed a counterclaim. They said I had violated my lease by having an unauthorized occupant, my younger sister, who had stayed with me for 6 weeks the previous spring while she was relocating from Savannah to Atlanta and getting herself established. I pulled out my lease and read the unauthorized occupant clause. The provision applied to occupants staying longer than 30 consecutive days. My sister had stayed 38 days. It was the only thing they had on me. A 7-day overstay on a couch in my own apartment, which I had been living in for 3 years without a single issue. That was their case. That was all of it. My attorney looked at the counterclaim, set it down on the desk between us, and said, "They're going to regret filing this." I was beginning to understand what it felt like to be on the right side of the law. It was not triumphant, not yet. It was quieter than that. It was the sensation of standing on solid ground after a long time of not being sure where the ground was. Update 2, Month 3. The pressure arrived the way pressure usually does, not from one direction but from several at once. The landlord's attorney sent a letter offering me $3,000 to drop everything and vacate within 30 days. When my attorney read it to me over the phone, I had to ask her to repeat the number. $3,000. I had $2,200 in savings. $3,000 was more than I had. Some part of my nervous system registered it as enormous. My attorney said no before I finished processing the number. She didn't ask me. She just said, "We're not selling this for $3,000. Then she asked me if I agreed. I said yes, though my hands were not entirely steady when I said it. My mother told me to take the money and move. She said it gently, the way she says everything difficult, with love and with fear underneath the love, because she has spent her whole life being told that certain fights are not winnable, and she believed it, because nothing in her experience had taught her otherwise. "You can't fight these people, baby," she said. "Take the $3,000 and find something nice." My best friend told me I was going to spend more on legal fees than I'd win. She didn't know about the contingency arrangement. I tried to explain it and she said, "Just be careful." I appreciated the concern and felt utterly alone with the decision anyway. The landlord himself appeared at the building twice during the second month of litigation. He didn't speak to me. He just walked the hallways, slowly, making himself visible. I don't know if this was intentional intimidation or just a man checking on his property. Either way, I registered it. I noted the dates in my spreadsheet. A neighbor stopped me in the mailroom one afternoon. She was 44, month to month, had lived in the building longer than I had. She spoke quietly. "I heard you're fighting him," she said. "Be careful. He owns 6 buildings." I thought about what she said for the rest of that day. He owns 6 buildings. She had meant it as a warning. She was telling me the scale of what I was up against, the resources, the experience, the insulation that comes with owning property and managing tenants for years. I heard something different. I heard, a man who owns 6 buildings has made the same mistakes in 6 buildings. A landlord who doesn't send security deposit notices doesn't send them once. A landlord who ignores mold complaints doesn't ignore one mold complaint. The scale of what he owned was not intimidating to me. It was a pattern. And patterns, in legal proceedings, are evidence. Update 3, Month 5. The deposition was on a Thursday morning in April. I had prepared for it the way I prepare for things that scare me, obsessively and in advance. My attorney and I had spent 4 hours the previous week going through every question she anticipated and every answer I would give. She told me to answer only what was asked. To pause before responding. To say, "I don't know," when I didn't know, rather than filling the silence with explanation. She said silence in a deposition is not weakness. She said juries, and opposing attorneys, read into people who talk too much when they're nervous. My hands shook during the deposition. I answered every question anyway. The opposing attorney tried to make the sister staying 38 days issue sound like a willful, repeated violation. I answered calmly that I had not reviewed the exact day count at the time, that my sister was in a transitional housing situation, and that the moment I was aware of any potential lease concern I had taken steps to address it. He tried to suggest I had fabricated the mold documentation after receiving the eviction notice. I produced the original submission timestamps from the portal and my own phone's photo metadata, which showed the date and time of the original photographs down to the second. He did not ask about those photographs again. By month 5, I learned, the landlord's insurance carrier had been brought in to review the file. This was information my attorney shared with me over the phone one evening, her voice carrying the particular quality of someone who is telling you good news but wants you to understand why it is good news before you react to it. Insurance carriers don't like mold cases, she said. They don't like documented habitability violations with a paper trail. They especially don't like retaliatory eviction timing that is going to be visible to a jury. And they really genuinely, specifically do not like landlords who own 6 buildings and have not been sending security deposit notices to any of them. She paused. He has a problem that is much larger than you, she said. You're the problem that introduced him to that fact. I sat with that for a long time after we hung up. Part 4. The Settlement. Update 4. Month 7. The case never went to trial. In month 7, the landlord's insurance carrier put forward a settlement offer. My attorney called me on a Wednesday afternoon and read it to me while I sat in my car in the parking lot of the dental office where I worked, still in my scrubs, the engine off. $38,500. The right to remain in my apartment through the end of my lease, 8 more months, at my current rent, with a written non-harassment clause. Written remediation of the mold within 30 days, with third-party verification. My attorney recommended accepting. She laid out her reasoning methodically. The offer was strong, the mold remediation was a tangible health improvement I would receive immediately, and the risk of trial, while manageable, introduced variables neither of us could fully control. The insurance carrier had made a calculation that settling was less expensive than the exposure they faced if we prevailed at trial. They were probably right about that calculation. I said yes. We signed the paperwork on a Friday morning. I sat in the parking lot of my attorney's office afterward, just sat in my car, engine running, going nowhere, and called my mother. She answered on the second ring. I told her what had happened. The number. The terms. The mold remediation that would happen within the month. She was quiet for a long time, long enough that I checked the phone to make sure the call hadn't dropped. Then she said, I didn't think that was going to work. I know, Mom. Another pause. I'm sorry I told you not to fight. It's okay, I said. I fought anyway. She started crying a little. So did I. We stayed on the phone for another 20 minutes talking about nothing in particular, the way you do when something has shifted and you need to adjust to the new shape of things before you can talk about it directly. I drove home. The same apartment. The same East Point neighborhood. My bathroom ceiling still had mold, but a contractor was coming in 3 weeks, and I had documentation that he was legally obligated to come. My life had not changed yet, but the trajectory had. Update 5. The Pivot. The settlement check arrived 6 weeks later. $38,500, minus my attorney's contingency fee of 25%, $9,625. Net proceeds, $28,875. I sat with that number for 3 weeks. I made a spreadsheet, because I make spreadsheets. I looked at my student loan balance, $28,000. I looked at my settlement net, $28,875. I looked at that gap, $875, for a long time. Then I paid off my student loans. All of them. Every dollar. In one transfer on a Thursday morning, I eliminated debt that had been a fixed feature of my adult life since I was 22 years old. My monthly cash flow increased by $310 immediately. That was the loan payment I had been making for 9 years that I would now never make again. I had $875 left from the settlement. I was, for the first time in my adult life, debt-free. I called my attorney to thank her. We talked for a few minutes. Then I asked her, almost as an afterthought, whether she happened to know anything about real estate investing. She laughed. Not dismissively. More like someone who recognizes a question they didn't expect but finds genuinely interesting. She gave me 3 book recommendations and 1 phone number. The phone number belonged to a 47-year-old real estate investor who was also one of her clients. Tell her I sent you, she said. And bring a spreadsheet. Part 5. The Full Circle. I spent the next 4 months learning. Not casually. The way I had learned Georgia tenant law, with highlighters and late nights and a compulsive need to understand the mechanics of a thing before I trusted myself to act on it. I read about FHA loans and down payment assistance programs. I read about cash flow analysis and cap rates and the difference between appreciation markets and cash flow markets. I built models in spreadsheets. I talked to the investor my attorney had connected me with. She was direct and patient and asked me good questions, the way my attorney had, and I started to understand that the people who are best at navigating complicated systems share a particular quality. They are not intimidated by information. They collect it. 8 months into my lease extension, the one I had earned through litigation, I had saved $11,200. My savings rate had completely changed once the student loans were gone. $310 a month that used to go to debt was now going into a high-yield savings account, along with an additional portion I had been putting away with the same anxious discipline I had once applied to paying rent early. I started looking at properties. The Georgia Dream Homeownership Program offered down payment assistance of up to $7,500 for first-time homebuyers. FHA loans required 3.5% down. For a home at the right price point, these two programs together could essentially eliminate my out-of-pocket cost at closing. This was not a loophole or a secret. It was a program that existed specifically for people in situations like mine. I had just never looked for it, because I had never thought homeownership was a thing I was working toward. I had thought I was a renter. Renters rent. That was the logic, and I had accepted it without examination. I examined it now. I found a 3-bedroom ranch in East Point, the same neighborhood where I had rented for 3 years. Listed at $219,000. Move-in ready. The previous owner had relocated for work, a motivated seller, 44 days on market, a property that had not found a buyer because the buyer pool had softened slightly in the preceding months, and this particular listing needed someone who was ready to move decisively. I was ready. I offered $211,000. They accepted within 48 hours. FHA down payment at 3.5%, $7,385. Down payment assistance grant, $7,385, covered entirely. Closing costs, $4,200. I negotiated seller concessions to cover the closing costs entirely. Out of pocket at closing, $0. I closed on a Thursday morning. I signed my name more times than I had ever signed it in a single sitting, and each signature felt slightly unreal, the way significant things sometimes do when you are still partly the person you were before they happened. They handed me keys. I drove to the property alone. I sat in the driveway for 11 minutes. I was not ready to go inside yet. I needed to understand what was happening. Not intellectually, I understood it intellectually, but in the deeper way that takes longer, the way your body needs time to catch up to what your mind has already processed. Then I went inside. I walked through every room. The living room with its high ceilings. The kitchen with the window over the sink. The 2 spare bedrooms, one of which would become a workspace, because I needed a place to keep spreadsheets and folders and a growing collection of books about real estate. I walked to the master bathroom. Looked up at the ceiling. Clean. White. No mold. No damage. No history. I stood there for a moment. Then I took a photograph of the ceiling. Old habits. I can't help it. I photograph things that matter to me, and ceilings matter now, and I knew even in that moment that this particular photograph would mean something different from the one that had started all of this. That one had been evidence of what someone had taken from me. This one was evidence of what I had built. Epilogue. 8 months after the settlement was signed, I was reading through a local Atlanta tenant advocacy newsletter. I had subscribed to it during the litigation and kept subscribing because the information was useful and because I had developed what I can only describe as a professional interest in landlord accountability, and I found a brief news item near the bottom of a section on code enforcement actions. My former landlord had been cited by Fulton County Code Enforcement for habitability violations across 3 of his 6 buildings. 2 other tenants, in buildings I had never set foot in, had filed complaints within 6 months of my case becoming part of the public court record. A public court record that detailed, specifically and in writing, the categories of violation that this particular landlord had a documented history of committing. He was facing $84,000 in fines and mandatory remediation orders across multiple properties. I screenshotted the article. I texted it to my attorney with no message. She responded with a single emoji. Balance scale. 14 months after closing, my East Point ranch appraised at $247,000. I had $36,000 in equity. My mortgage payment was $1,290 per month, $50 less than the rent I had paid to a man who tried to put me out with a defective notice and no specification of violations. I was paying less every month to own than I had paid to rent. I was building equity instead of generating it for someone else. I started looking at a duplex 2 streets over, listed at $289,000. 1 unit occupied, 1 vacant. I ran the numbers. The cash-on-cash return at current rents was workable, and the vacant unit gave me the flexibility to either rent at market rate or, eventually, house hack if I needed to. I built 3 scenarios in a spreadsheet, conservative, moderate, and optimistic, and stress-tested all of them. I met with the investor my attorney had introduced me to. We had coffee. I brought the spreadsheet. She looked at it for several minutes, asking questions as she went. Then she looked up. "You've done this before," she said. "First time," I said. She studied me for a moment. "You're going to be fine," she said. I believed her. It was easier now, believing people who told me I could do something. I had practice. Here is what I want you to understand about this story. None of it required legal expertise. None of it required money I didn't have. None of it required connections or luck or any particular talent beyond the willingness to sit with an uncomfortable situation and ask what, specifically, the rules said about it. He slipped that envelope under my door thinking it was a form letter. It was, to him, one of many, part of a strategy he had probably used before and expected to work again. A tenant who didn't know her rights was a tenant who would pack her things and leave, and he would renovate the unit and relist it at $410 more per month and do the math that landlords do. I didn't know my rights. That was true. I knew how to use Google and I had a highlighter and I had 2 a.m. and nothing left to lose, and that turned out to be enough. I found an attorney who worked on contingency, which means the economic barrier that stops most people from accessing legal representation was not a barrier for me once I knew it wasn't. I documented my case with the photographs and maintenance request timestamps that my own anxious habits had already generated. I learned slowly and imperfectly but well enough that the law has specific rules and that those rules apply to everyone, including landlords who own 6 buildings and expect that scale to protect them. My mother told me I couldn't fight these people. I have heard that my whole life in various forms. You can't fight the landlord, you can't fight the system, you don't have the resources, you don't have the knowledge, you don't have what it takes. I filed in Fulton County Court on a Thursday, and suddenly these people had to show up with an attorney and answer questions under oath and have their insurance carrier review the file and calculate whether going to trial was worth what they were going to lose. Turns out you can fight them. You just have to know where the courthouse is. The eviction notice is in a folder in my home office, the 3rd bedroom, the one I converted into a workspace with a desk I bought secondhand and 2 bookshelves full of everything I've read in the past 2 years. The folder is labeled Starting Point in black marker. Because that's what it was. He just didn't know he was handing it to me. I own a house now, in the same neighborhood where he tried to put me out. My mortgage is $50 less than my old rent. My bathroom ceiling is clean. He owns 6 buildings and an $84,000 code enforcement problem. I don't know if that's justice. I know it's math. And I've gotten very good at math.